opined by a very important political philosopher, Charles de Montesquieu, that in a state, all men are born equal, but they cannot continue in this state of equality. The society makes them to lose it, and it can only be recovered through a positive action of the state. Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya, and in today's episode of Polity Primer, we are going to discuss a very important constitutional right that has been ensured to us by our Indian Constitution. The title of our today's discussion is the Free Legal Aid in India. In this discussion, we'll firstly study about the constitutional provisions that guarantee us the right of free legal aid. Then we are also going to examine its history. We are also going to analyze what is the Supreme Court Legal Services Committee. Then we are also going to see the composition of the Supreme Court Legal Services Committee. Then we are also going to see what the Legal Services Authorities Act says. And lastly, we'll see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, recently Justice Gavai has been appointed as the chairman of the Supreme Court Legal Services Committee. So this brings us to the moot question of our today's discussion, that what is the right of free legal aid in India and the constitutional provisions regarding it. Now let us have a look at the constitutional provisions which guarantee us the right of free legal aid in India. So our constitution works on the principles of constitutionalism. And rule of law. And that is why it guarantees us this very important legal right, namely the right to receive free legal aid. The need for providing legal services has been underlined in many provisions of the Indian Constitution. And the most important provision is Article 39 Clause A, which has been added to our Indian Constitution by the 42nd Constitutional Amendment Act of 1976. And it states that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are not denied to any citizen by way of economic or other disabilities. So this is the important right that guarantees to us a right to receive a free legal aid in India. Now let me know in the comment box below the kinds of justice that have been promised to us by our Indian Constitution preamble. Moving forward, not only Article 39 Clause A, but also Article 14, which talks about right to equality, and Article 22 Clause 1, which talks about rights to be informed of grounds for arrest, also make it obligatory for the state to ensure equality before the law and a legal system that promotes justice based on equal opportunity. So if we want to create a truly equal society, we have to bring the unequals on the same footing, and that is how a true equality can be achieved in our society. So right to free legal aid in India has various dimensions. So firstly, it is a paramount duty of a welfare state. India is a welfare state, and that is why we have this directive principles of the state policy. Secondly, need for a healthy democracy. Thirdly, needed to implement the rule of law. Fourthly, a true spirit of equality. Fifthly, an important part of natural justice. an important part of natural justice. Natural justice. And sixthly, and the most important, right to free legal aid in India is a social movement. So all of these aspects are the various dimensions of the right of free legal aid in India. So not only our Indian constitution but also our criminal laws ensure this right. So section 304 of our older CRPC states that whenever a trial is going on in the court of session and the court feels that the accused cannot engage a lawyer just because he cannot afford to engage a lawyer, so the court is going to provide that person a defense lawyer to defend him at the expenses of the state. So not only our Indian constitution but also our criminal laws embodies the right to receive free legal aid in India. Moving forward to the historical background of the right to receive free legal aid in India. Although the idea of a legal aid program was earlier floated in the 1950s, it was in the 1980 that a committee at the national level was established under the chairmanship of the then Supreme Court Judge, Justice P.N. Bhagwati. So, Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. Justice V.R. Krishna Iyer are known to be the pioneers of legal aid in India. So what is the landmark Supreme Court judgment which guarantees to us a right of free legal aid? It is the Husainera Khatun versus State of Bihar. Khatun versus State of Bihar. This case is also known as the legal aid case, and this is a landmark Supreme Court judgment on the right to receive free legal aid in India. So the Committee for Implementing Legal Aid Schemes started monitoring legal aid activities throughout India. Moving forward to the Supreme Court Legal Services Committee. So the Supreme Court Legal Services Committee was constituted under Section 3 Clause A of the Legal Services Authorities Act of 1987. So as I have mentioned before that Article 39A is the directive principles of the state policy. So a statutory backing was required to provide the right of free legal aid in India, and that is why this Legal Services Authorities Act of 1987 was enacted by our Parliament to provide free and competent legal services to the weaker sections of the society. So it is the aim of the Supreme Court Legal Services Committee to provide justice to the weaker sections of the society in cases failing under the Supreme Court's jurisdiction. It consists of a sitting Supreme Court judge who is the chairman along with 9 other members possessing the experience and qualifications prescribed by the center, and these chairman plus 9 other members are nominated by the Chief Justice of India. So moving forward to the composition of this Supreme Court Legal Services Committee, as I have mentioned before also that it comprises of 1 chairman plus 9 members who are nominated by the Chief Justice of India. So the committee in turn can appoint officers and other employees as prescribed by the center in consultation with the Chief Justice of India. And under Section 27 of the 1987 Act, the center is empowered to make rules in consultation with the CJI by notification to carry out the provisions of the Act. And in all of this, in securing free legal aid to the weaker sections of the society, this Supreme Court Legal Services Committee plays a very important role. Moving forward, let us analyze what the Legal Services Act says. So as I have mentioned before also that Article 39 Clause A, being the directive principles of a state policy, required some statutory backing, and that is why in 1987 the Legal Services Authorities Act was enacted by the Parliament. It aims to provide free and competent legal services to eligible groups including women, children, SC/ST community and EWS categories, industrial workers, disabled persons and others. And mind you, these categories of people who are entitled to receive free legal aid in India have been asked in your mains exam, mains PYQ. So this is a previous year question, and hence this topic becomes very important from the perspective of your examination. Moving forward to a very important body that has been constituted under the Legal Services Authorities Act, and that is the National Legal Services Authority, or the NALSA. So the NALSA was constituted in 1995 to monitor and evaluate the implementation of legal aid programs and to lay down policies for making legal services available. Not only NALSA, there are state legal services authorities as well. State Legal Services Authority and DLSA, that is the District Legal Services Authorities. So all of these function under the NALSA, and NALSA has brought free legal aid to the masses of the society. NALSA is also responsible for the organization of LoAdalats, which help in amicable settlement of the disputes. Settlement of the disputes. So LoAdalats are conducted by NALSA, and they form a very important part of giving free legal aid, of resolving the disputes amicably. Some of the roles and functions of NALSA are: firstly, to lay down policies and principles for making legal services available under the Act. Moving forward, to frame effective and economical schemes for legal services. So there are many schemes that are run by NALSA so that free legal aid can be reached to the society. To monitor and evaluate the implementation of the legal services under the Act, to conduct legal awareness programs and promote legal literacy among the people, to encourage settlement of disputes by way of negotiations, arbitration, conciliation and mediation. So these all are done by NALSA, and LoAdalats are also constituted by the NALSA, as I have mentioned before. To coordinate and cooperate with other governmental and non-governmental agencies engaged in providing legal services. Now this was all about the roles and functions of the NALSA. So what are the challenges that are being faced in implementing free legal aid in India? So the challenges include lack of legal awareness and literacy. Legal awareness and literacy. Secondly, lack of support by the lawyers and advocates. Lack of support by the lawyers and advocates. Thirdly, lack of resources. Fourthly, lack of power to the LoAdalats. So if we want to administer legal aid more effectively and to implement it more effectively, we have to increase the legal awareness and literacy among the people, because many people are not aware about their legal rights. Secondly, we need to pay the lawyers and advocates their justiciable fees. Then definitely we need to increase the lack of resources for the NALSA so that it can run its programs and schemes. And we need to give more powers to the LoAdalats so that they can settle more and more cases amicably. With this, we come to a conclusion of our today's discussion. So it can be concluded that in a democracy, it is important that the poorest among the poor, the weakest among the weaker, receive justice and they are not facing injustice. Now let us analyze a practice question for your prelims examination. So the question is, consider the following statements with respect to the NALSA or the National Legal Services Authority. Your statement number 1 is, the NALSA is a constitutional body to provide free legal services to eligible candidates. Your statement number 2 is, the Chief Justice of India is a patron-in-chief for NALSA. Which of these statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. Kindly drop your answers in the comment box below. Now let us analyze a practice question for your mains examination. So the question is, who are entitled to receive free legal aid? Assess the role of the National Legal Services Authority or the NALSA in rendering free legal aid in India. And this is a PYQ that has been asked in the year 2023. So in introduction, you'll write about the right to free legal aid, the constitutional provisions regarding it, which we have discussed, the various dimensions of free legal aid in India, as I have discussed. Then you will talk about the constitution of NALSA, the role NALSA plays in administering free legal aids in India. For example, running various programs, scheme. Then you will talk about the categories of people that are entitled to receive free legal aid in India, such as the women, children, SC/ST community, EWS categories, disabled persons, etc. So we'll write about the categories of people who are entitled to receive free legal aid in India. Then we'll explain the roles and functions of NALSA. For example, running programs, schemes, increasing legal awareness, conduction of LoAdalats, etc. And then you can conclude holistically that yes, we need to increase our legal literacy, legal awareness. We need to give more powers to the LoAdalats. We need to have more resources dedicated towards the programs and schemes of NALSA. Then you can also write that yes, we need to pay the lawyers and advocates well so that they can support the NALSA. So you can conclude very holistically. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.